Go live in 5, 4, 3, 2, 1.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Before Mr. Hibbner calls the case, just a couple of comments here. Technology is working generally very, very well. Problems sometimes arise. If they do, counsel, don't worry about it. We'll simply take a pause and work through it. We appreciate your participation in this Zoom hearings, because it has enabled us during this unusual times to keep the work of the court moving for the people of the state of Tennessee. Mr. Hibbner, call the case, please.
In re Porcalyn N.
We'll hear from the appellant.
Your Honor, as a general description of the concerning facts in this case, looking at the father's point of view, and he's the only one that has appealed the termination, but looking from the father's perspective, the father's biggest problem is that he did things that the court would tell him not to do simply for the benefit of his children. He provided the mother a home. He moved in with the mother for some time to try to lift her up to a point where they could share custody of their kids. And the bottom line is, if you look at many of the father's failures, they are the result of the fact that he was trying to keep this family together. Now, having said that, I'm not trying to throw the mother under the bus in any form or fashion. There are particular issues that fathers had trouble with, one of which obviously was several failed drug screens towards the middle. He had clean drug screens in the beginning, had clean drug screens in the end, but candidly, during the middle of this period of time, he had some problems. But the reason I start with that is because most of my argument is a technical argument about the failures of DCS and what they failed to do to bring this case to termination properly. And what I mean by that is they found 5 grounds of termination against the father. If you look at the technical aspects of each of those 5 grounds, they have simply failed to comply with what the law would require them to comply with. The grounds don't meet what DCS and what the juvenile court did. The first ground, obviously, is the failure to pay child support. Okay, abandonment by failure to pay. Well, when you look at that, the trial judge concluded that yes, father had done some time in jail, really never calculated a 4-month period of time, but said, there's lots of 4-month periods of time. I see at least 3 4-month periods of time we can use. Well, that's not the standard that this court can apply. That's not the standard of what the ground says. There are 2 separate, distinct lines by which the court can find failure to pay child support. One is during that 4 months immediately prior to the termination, which is the ground that was alleged by DCS. And the other one was a period of time if the father had been incarcerated, how we calculated that time. DCS never alleged that ground. All they alleged was the very first ground about the 4 months immediately prior. The court never found that. The court was relying on the second ground to make its finding. That's just simply inappropriate based on the current case law. And in fact, the court found that to be true. Actually, one of my cases where I represented the parents, and that was in re AVN, where the court said you can't skip from one to the other. And the fact that he may or may not have been found guilty or have been found to not have paid child support at a prior time doesn't bootstrap your argument under the first code section.
Mr. Bennett, as I read the briefs, it was my understanding that the court really didn't articulate the specific 4-month period it was looking at. But the proper 4-month period would be that September 8th, 2019 through January 8th, 2020. Is that correct?
That would be correct.
And if
But-
we do a de novo review of that, can we not conclude, I think the evidence established that during that time, he only paid $141 in child support?
That would also be correct, but also the court has to recognize that there was a period of time that he was incarcerated during that time. The trial court never gave us the benefit of calculating when he was in and when he was out of jail. But we don't know what that $141 looks like as it relates to the period of time he's out of jail.
And I'll obviously have to go back and look at the record, but I think what the appellee is saying is that he was arrested during that 4-month period of time, a couple of times, but he was released on the same day. Does the record bear that out?
Your Honor, when I read that in the appellee's brief, I found that to be interesting, but by then I had surrendered the record back to the Court of Appeals.
We'll take a look at it.
Okay. And again, the second ground is the ground of.
Counsel, before you move on, let me ask you, if that's what the record shows, do you agree or disagree that means we will be looking at that 4-month period of time if he's arrested but released the same day?
I would tend to agree with that. Yes, sir. But
Okay.
at the same time, I would say that there's still $141 there. So it was not just a complete failure to pay child support.
Thank you.
The second ground was his failure to provide a suitable home. And the DCS worker, the caseworker, admitted that at the time the child was brought into custody, the father was not in the home of the mother. The child was removed from the home of the mother. The code section specifically requires that the child has been removed from the home of a parent before we could find that the failure to provide suitable home. But equally important is if you look through the record, you'll see that the father basically maintained a suitable home during virtually the entire time of this case, other than times he ended up again incarcerated based on him and his mother's altercations. So if he's not
interrupting counsel with regard to that issue you just referenced, was father a party to a lease where the child was residing?
the father actually signed the lease to where the child was residing.
So does that have any bearing with regard to this ground?
I would say not, Your Honor, and I'm not sure that there's case law on that very point, but it said it had to be removed from the home. The fact that the father signed the lease, the testimony was he didn't live there, and that came from the DCS workers themselves. It did not, well, the father also testified to that, but it came directly from the DCS worker that he did not believe the father lived there.
Was he paying rent?
He was paying the rent.
Thank you.
Okay. But again, assuming that we determined that it was his home and the child was removed from his home, we also have to look at the father's residency. Father maintained residence. Father never had a problem maintaining residence. The DCS worker, again, testified several times that the times he went out to the home, whether it was the father's home or whether the father's and mother's home at a later time, that it was always an appropriate residence. I just simply think that DCS failed to find that ground as well. Okay, one of my most perplexing issues in this case relates to the next ground, and that's the failure to substantially comply with the permanency plan. And the reason I say that, and the court's got the case law, but we have a situation where the father was never adjudicated, that the child was dependent and neglected in his care. The reason I find that important is because if you're not adjudicated, if there is no finding against you, then anything you're asked to do on the permanency plan becomes completely irrelevant. And in fact, there's a case on point on all fours on that one that I cited to in my brief. And that case is, let me go back one page. Well, I show it as quoted through Henry Valentine, but I know that there's another case in my brief that identifies specifically a case that's on all fours. It says that if you're not adjudicated, then how do you, if there's no finding against you, then how can you substantiate what you're doing under the permanency plan? The next is that persistence of conditions. I would first argue that the child was not removed from the father's care, but equally important that the father had done things that would keep persistence of conditions from being an issue. He had done an IOP, he had done his, drug screens. He was successfully passing drug screens by the time of the termination. He had housing, he had all the things that you would expect him to have. And again, his biggest downfall during the entire period of time the child was in custody was he continued to have a relationship with the mother, which again caused him to end up in jail a couple of times based on allegations made against him by the mother. Other than that, I think the father was substantially ready to take this child back. And likewise, the failure to, or the inability to manifest an ability and willingness to take the child on, I think again that all those factors lead to the fact that show that the father was willing and able to care for this child. But equally important in that regard is the issue of the danger to the child. The court never enumerated anything that would bring the child into danger, or the fact that the child would be in any danger if as a result of the parent's inability or unwillingness to care for the child. That, again, a very important aspect of the court's finding is completely omitted from the trial record. I would say that the court therefore did not substantially prove that ground as required by law. The issues of best interest, my argument is always and will ever be that a child's best interest is always to be with its biological family if possible. That, in my opinion, is the top tier, most important aspect of anything we do in the juvenile system. And that said, this father is not far off. Certainly, if this court does not grant the termination or affirm the termination, the child's not going back to the father. Child's still with DCS. Father's still going to have to prove himself to DCS before anything happens. And I think in this case, the father's close enough that he could. Thank you.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
May it please the court. Good morning. My name is Amber Seymour with the Attorney General's Office on behalf of the appellee, the Department of Children's Services. Your Honors, this case is about a father who, despite having many services offered by the department, chose to continue to abuse drugs, engage in criminal activity, and engage in domestic violence. The termination of his parental rights should be affirmed because first, 5 separate grounds were established to support termination of his rights. And as this court is aware, it need only affirm one of those to move on to the second issue, which is that termination is in the child's best interest. Turning to the first ground, father abandoned the child by failing to financially support her. The father has argued that the court erred in calculating the 4-month period. Judge Davis, you were correct that the proper statutory period here would be from September 8th, 2019 through January 8th, 2020, because the termination petition was filed on January 9th, 2020. And though father was incarcerated at 2 different points during this period, those were what I consider catch and release. Father was arrested and he was released the same day. I do realize my footnote 15 did not have a citation to the record for that. In my statement of facts, there is a section, I think, called Father's Criminal History that lays out all of the dates of his arrest that were described in the testimony. So I do apologize for that. But even though the court did not specifically identify the 4-month period here, the findings still cover the correct period of September through January Father made a total of 3 payments that equaled about $141.90, which did not equate even to his single monthly obligation of $205 per month. He reported working at Premier Handyman, but instead of paying his support obligation, he chose to spend his money on unprescribed Suboxone that he purchased on the street for $5 per pill. So any support that he did pay, that $141, was nothing more than token support, given his ability to pay what his monthly obligation was, and that he was using his money to purchase illegal substances instead. For the ground of suitable home, Father has argued that because the child was not removed from his home, that it was the mother's home, this ground cannot apply. However, he is applying an old version of the termination statute, the version that was in effect at the time of this petition, and that is still in effect at this time, is that the child must be removed from the home or the legal or physical custody of the father. And here, the bench order that removed the child did so from both parents' custody. And so this court need not even determine whether or not that was actually the home of the father, because it's undisputed from the record that the child was in at least his custody and removed from that.
Well, counsel, let me ask you, tell me the language again, legal and physical custody, or legal or, I mean, tell us the language again, please.
I think this is a direct quote. I'm so sorry if it's not. From the home or physical or legal custody of the parent. And that was amended, and I believe the July 1st, 2018 amendment was what changed that. The department did make reasonable efforts at that time to help Father. Even though Father had housing at that time, his home was still unsuitable because it was full of domestic violence and drug use and repeated criminal activity. The department arranged for domestic violence classes, which Father did not attend. He continued to engage in domestic violence and was repeatedly arrested for altercations against the mother. He was incarcerated at trial on charges of kidnapping, aggravated assault, and coercion of a witness. The department paid for his mental health assessment, his alcohol and drug assessment, and for the recommended outpatient treatment, which he completed, but he continued to still use drugs. He tested positive for unprescribed Suboxone 9 times from April through October of 2019, and he admitted that he used methamphetamine in January of 2020. And so the ground of suitable home was still established because the house was clearly inappropriate for a young child. For the ground of substantial noncompliance with the permanency plan, opposing counsel has argued that because there is no final dependency and neglect adjudication against the father, that the plan's responsibilities must be unreasonable or irrelevant. But that simply cannot be true. A permanency plan must be developed within 30 days of removal, and there is virtually never a final adjudication of dependency and neglect within that first 30 days. So it does not make sense with the statute to require final dependency and neglect adjudication before having reasonable responsibilities in the permanency plan to work towards reunification. Nor does the termination statute require it. It's silent about any requirement of a final dependency and neglect adjudication. And the responsibilities here were reasonable and related to conditions that necessitated continued foster care. The biggest problems were Father's domestic violence, criminal activity, and drug use. He did complete, he was required to complete domestic violence and anger management classes, a mental health assessment, an alcohol and drug assessment, to pass drug screens, to ensure other adults in the home were free of domestic violence and drug use, and to resolve legal issues and refrain from incurring new charges. Though he did complete the assessments and the outpatient treatment, which should certainly be commended, it was clearly going through the motions without actually addressing the root problem because he still continued to use drugs. Once again, he failed 9 drugs for Suboxone in 2019, and he admitted that he used meth in January of 2020. He refused other drug screens, and then he failed to participate in even more drug screens that were being offered at court. He continued to associate with a mother who he admitted he knew used drugs every day and that he had seen her use drugs in the home. He testified that he let her use the drugs because he didn't want her to become angry with him. He was arrested many times throughout the custodial period. and he never addressed the domestic violence issues. He never participated in the classes. He never did any anger management classes. Repeatedly arrested for physical altercations, and again was still incarcerated at trial for some of these charges. For the persistence of conditions ground, again, this is another ground where the statute has changed. I believe also on July 1st, 2018, there is no requirement that it's only removal from the actual home for the ground to be triggered. It's from the parent's home or their physical or legal custody. And again, the bench order does remove the child from father's custody as well. And then the statute also does not require a final dependency and neglect order. The language of the statute is that the child must be removed by a court order entered at any stage of the proceedings in which a petition has been filed that alleges dependency and neglect. And here, the record contains a petition filed by DCS that alleged dependency and neglect against the father. And there was the removal order that also removed the child on allegations of dependency and neglect. Conditions persisted that prevented reunification with the child. Father, again, continued using drugs, testing positive many times for Suboxone and admitting to using meth. He continued to associate and live with mother, who was a known drug user. He is repeatedly arrested. He engaged in domestic violence and failed to attend the classes to address that. And he did not complete anger management courses. There was also little likelihood that these conditions would be remedied soon to allow for reunification in the near future. Father has had since April of 2019 to remedy these conditions. And though he has made some efforts, especially early on, he just has not remedied them. He's continued to engage in behaviors that are wholly inappropriate and unsafe for the child to be exposed to. And even at trial, he was still incarcerated and was facing a potential prison sentence. So there was no guarantee that he would even be able to have a physical home anytime soon at the time of trial. And then the final element, continuing father's relationship with the child would diminish her chance of an early integration into a permanent home. The child has been in the same foster home since she was removed in April of 2019 when she was 14 months old. She's done well in that home. She's bonded with the foster parents, and they seek to give her a permanent home and adopt her. And then the final ground that was found is failure to manifest an ability and willingness to assume custody of the child. Father here certainly did not manifest either an ability or a willingness. He continued using drugs. He continued to engage in domestic violence, which led to repeated arrests. He was incarcerated at trial. He failed to pay child support consistent with the guidelines, despite reporting that he was employed. And then for some reason, even though he had visited the child early on in the custodial episode, visitations ceased in October of 2019 without explanation. And then returning the child to father's custody would pose a risk of substantial harm to her welfare. He was incarcerated at trial. He could not take custody of her at trial, even if given the opportunity. And even if he were released from incarceration soon, as he had hoped to be released on probation, the child would only return home to a house that's still full of drug use and domestic violence that has remained unaddressed. And this creates nothing more than a hazardous condition to send a young child to. So because at least one ground has been established by clear and convincing evidence, this court must also determine that termination of father's parental rights is in the child's best interest. As this court is aware, there are 9 non-exhaustive factors to consider in this analysis. And so I will just highlight a few that seem to be some of the most important ones here. Factors 1 and 2 are extremely important because father has not made any adjustment of circumstance, much less a lasting adjustment, even after getting reasonable efforts from the department. Father continued using drugs even after completing outpatient treatment. He continued engaging in domestic violence, leading to his repeated arrests. He failed to participate in the classes designed to address these issues, even though they were being offered and arranged for him by the department. Factor 3, even though father had regular visitation early on the custodial episode, it just stopped in October 2019 without any explanation. Factor 7, the home was unsafe for the child. There was drug use in the home, both from father and from mother. There was criminal activity in the home, and there was domestic violence between the two of them that had been completely unaddressed throughout the custodial episode by father. And then factor 9, father failed to pay child support consistent with the guidelines. He made 3 payments total, which did not even equate to what he owed for a single month. Instead, he chose to spend his money on unprescribed Suboxone off the streets. And then factor 5, which is always an extremely important factor to consider, is that this child is doing so well in the foster home. She's been there since she was removed in April 2019 at 4 months of age. She had a relationship with the foster parents. She was there with the foster parent siblings and other foster kids, and they each had their own bedroom. And the foster parents wished to adopt her if given the opportunity. So for these reasons, the department asks that the termination of father's parental rights be affirmed. Thank you.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Your Honors, the distinction between removed from the home of a parent or removed from the legal or physical custody of the parent really is not applicable here. And the reason I say that is that the state would rely on a bench order that says we're removing from the family. Well, a bench order is found on probable cause only. A bench order does not rise up to the level of clear and convincing evidence. In fact, all the testimony at the termination trial directed otherwise. So when you're looking at the issue of clear and convincing, certainly you can look at the bench order, but that is not determinative in and of itself because it's probable cause only. Likewise, the same can be said about the permanency plans. Permanency plans are approved by the court on probable cause issues only. I would suggest the reason for that is we don't want to spend a whole lot of time arguing about permanency plans when it's just simply best to get them done and move forward. But at the same time, those hearings are not clear and convincing hearings. They're probable cause hearings only. So they cannot rise to the level that the state would wish them to rise to.
Counsel, I mean, so are you arguing that the proof wasn't clear and convincing that your client had legal custody of the child?
I do not think it was clear and convincing. The legal custody of the child at the time was with the mother.
What shows that in the record?
Nothing shows it in the record, but at the same time, nothing shows otherwise in the record. And it's the state's responsibility to prove otherwise. So I think the distinction drawn by the state is a very good distinction, but I still don't think it's applicable in this case. Again, the state made reference to the fact that the father was charged with certain crimes. Being charged with the crime is not clear and convincing evidence of having done that crime. In fact, the two crimes that father was charged with, kidnapping and coercion of witness, were not found against the father. That was testified to by the father, and yet the state at the termination hearing never proved otherwise. So the answer is, again, that has not risen to the level of probable cause or clear and convincing evidence that it needs to. The fact that the father could not have received custody at the time of termination, I would agree with the court on that. I would agree with the state on that. However, custody is not returned if a termination hearing is denied. What happens is it goes back. Father still has to work his plans with DCS, and he still has the obligation to complete those things he's required to do. But before we do that, we first need to adjudicate against him, which has never been done. And that concludes my time. Thank you.
Thanks to counsel for both sides. We appreciate your briefs and your arguments on this. Mr. Hibner, if you'll recess court until 10:30, please.
This honorable court is now in recess until 10:30 a.m.
Thank you.